All right. Good morning, everyone. Good morning. And good morning to all of our listeners and joiners on virtual. We're so excited to have you all here. This is one of our bigger classes of the year, one of our most popular. It's our annual construction and employment law update with the fabulous team from Murphy Austin. So thank you for joining us. My name's Jillian Bender Cormier. I'm with Bender Insurance Solutions. I'm head of culture here. And we just want to welcome you. And a couple of things just to note, Edward kind of made mention to it. This is a recorded session. Hello to our virtual team over here. If you guys want to ask any questions, this is going to be an interactive experience. Please. So our in-house guests, raise your hand. Anybody that's joining us virtually, you can ask a question in the Q&A section in GoToWebinar. You are all in listen-only mode, all of our virtual folks, so we won't be able to hear you. We will be sending the recording and a copy of the slide deck following today's presentation. So, without further ado, I want to welcome up Edward Johnson, our Vice President of Construction Risk, who is going to be welcoming the Murphy Austin team. Thank you.
All right, good morning, everyone. As Jillian mentioned, this is one of our more popular seminars. We've been doing these Bender U classes for 15 years or so, and this has always been a very popular one, and we appreciate the ongoing partnership with the team from Murphy Austin. So, some quick introductions for these fine gentlemen. We've got Scott Alexander. Scott currently serves as the managing partner of Murphy Austin Adams. Scott practices business and commercial litigation throughout all of California, state and federal courts, with a primary emphasis in construction and real estate litigation, public contracts, and complex contract disputes. He doesn't do the easy disputes. We also have with us today Ken Schumacher. Ken Schumacher's practice focuses on all aspects of general civil litigation, with an emphasis on construction law, which includes the representation of contractors, developers, owners, design professionals, contract and real property disputes, not fake property disputes, business and commercial matters, and insurance coverage and litigation issues. Yikes. All right. And then you do all those things? So these Ken and Scott will present for the first portion of today's seminar, and then we'll take a small break in between for about 5-10 minutes, and then we'll bring up Aaron Silva, also with Murphy Austin. I'll do an introduction for him at that time. So, gentlemen, I'll turn it over to you.
All right. Well, good morning, everybody. Thank you for joining us. I'm trying to remember how many years we've done this now. 10, at least a decade. Yeah. So, feeling older. But anyway, that's a different story. So, thank you to Edward, to Jillian for inviting us. And like they indicated, we kind of break this up. The first half is going to be focused on construction laws and also new construction cases. And then the second half will be the exciting employment labor law changes, which is always interesting, especially in California. So again, I'm Ken Schumacher, this is Scott Alexander. And we like to make this interactive. Just out of the gate, some years are exciting. Some years have lots of good construction law changes and really meaty stuff. This is not that year. So I'll just tell you out of the gate, not a lot of really exciting things, but nonetheless, if you have questions or stories, things you want to ask us, please raise your hand. We do like it to be interactive. Don't want it just to be a lecture on our part.
Right. That's not necessarily a bad thing, that there's not a lot of changes, but we will highlight some of the laws, and actually I think one of the more significant issues that we'll talk about this morning are actually some changes on the litigation side on discovery rules. As far as what entities, parties may have to do when litigation is filed now, which I think to the extent you're going to be pursuing claims on mechanics liens or collection matters, there's a new statutory requirements about what has to be disclosed initially on the front end. That's going to impact everyone moving forward. So got a few issues I think that are going to be a little outside just the general construction realm that I think are going to be important.
And hopefully you stay out of litigation, yeah. But it is a very important change in our world. And would be in your world too. And something else about our firm, this is our 25th year, so it's very exciting for us. He's been here the whole time. And not only do we do construction law and labor and employment, we also have a real estate group, corporate tax, healthcare. So we're kind of set up to help businesses. And I think right now we have 34 lawyers, which has been a pretty consistent range for us. We are located in downtown Sacramento. So a little bit more about our firm. All right, so let's move on. So, well, what is today? Today's well, okay, go next. So, what is special about today? All right, well, it's actually National Ferris Wheel Day. If you didn't know that. So that's, if you like Ferris wheels, that's exciting.
Ken is a fountain of knowledge.
And what else? It's Library Lovers Day. So if you guys like
Lovers, I get that.
Yeah, it's a very exciting day. So, but nonetheless, it is Valentine's Day. So hopefully you guys will have plans, maybe not. I don't think I do, but anyway, hopefully you enjoy Valentine's Day. You came here to be with us. We greatly appreciate that. All right, so let's get into the new construction laws. So there's always additions and changes to license laws. So, and that's obviously governed by the Contractor State License Board, the CSLB. So the first law is AB 336, which changes the Business Professions Code. So we have a lot of codes in California. We have a lot of books, a lot of things online. The license laws are typically found in the Business Professions Code and in the 7000 series. And you can look those up online. If you really want to get into them, it's not very exciting, but nonetheless, if you wanted to read them, you could do so. And what this law indicates is starting July 1st, 2024, all contractors on file have to have on file workers' compensation insurance, must certify the renewal from the workers' comp on the codes under which the insurance is effective. And the classification codes describe the nature of the insurer. So it's just another layer where when you actually have to file a certificate, you have to identify also your codes. So it's just another administrative and procedural level that you have to go to on the workers' comp side. So again, like we said, it's not very exciting stuff, guys.
But unfortunately, we are contacted, frequently. We on our corporate side, we do a lot of business formation, entity formation, succession planning. A lot of contractors are experiencing succession planning these days. And many times you're moving corporate structure form from an S corp or a C corp to an LLC, have to get a new license. We have to stay very up to date and current on all licensure requirements because there are a million pitfalls and traps along the way. And all of you, if you have continuing projects and you're forming a new entity, you need to make sure there's continuity in the licensure moving forward. So, a lot of these, while they may be mundane, these are also traps as well, where you may get a license renewal that's kicked back. And we all know how quickly the CSLB, it performs for us. So, these are just, again, things to be aware of.
Yeah, and Scott's right. The license laws can be very draconian. And if you're not properly licensed, hopefully none of you have been in this situation, you may be prevented from seeking monies on a project. You may have to disgorge monies back to people if you're not properly licensed during the entirety of the work on your project. Workers' comp is a trap. It's another way that if you don't proper workers' comp, you may be deemed to be an unlicensed contractor. So again, it's important that you comply with all of these laws. All right, and then again, another change is AB 1204, again in the Business Professions Code 7035. This one requires specialty contractors to only subcontractors with the same license classification to employ persons who are classified as employees.
What does that mean?
It's kind of a mouthful. So if you're a specialty contractor and you're subbing out your work, it has to be somebody with the same license classification, and they have to have bona fide employees, basically. So you can't just go ahead and say, I'm going to do this work and use somebody else who's not properly licensed. And this really puts a burden on the specialty contractors to make sure that their lower tier subs are properly licensed and that you have employees or that they are signatories to a bona fide collective bargaining agreement. This is another trap. Okay, so again, this law has changed because we have had cases where specialty contractors have not used the right labor, have not used the right subcontractors to do the work. And so this is now tightening up the law a little bit on folks. So just as if you're a prime contractor you're contracting with subcontractors, you've got to do your due diligence to make sure they're proper license, DIR registered, all those things. This now puts a burden on specialty contractors to do the same with their lower tiers. All right. AB 1121. So actually, I indicated that we've got business professions code. This also now bolsters the labor code section, which is 1771.1 registration. And this now requires all awarding authorities to annually submit to DIR a list of ineligible contractors based on local debarment or suspension processes. So hopefully none of you have ever been in this position where you've been debarred by a local entity or suspended. It happens occasionally. And now the public entities have to present this to the DIR for them to publish to the world. And it's going to be made available through the project registration database. So what's important here is if you're a prime or you're a sub, you're contracting with somebody, you're going to have to go on the DIR site and make sure that that entity is not debarred or suspended. Because if they are, that's going to raise concerns and issues for you. And you need to be careful about listing them as a subcontractor or contracting with them. So this is kind of to send notice to the world as to who the ineligible contractors are. But this is now another due diligence effort on your part to make sure that people are properly licensed and can actually contract. So again, these first three laws are just kind of tightening things up and putting more of a burden on you to do your due diligence with everybody. Okay, and also with your workers' compensation. All right, this is a big one, and I do want to. There's a typo here. We have AB 336. It's actually, I think it's AB 660. My fault. My typo. I'll take credit for that one. And this requires all CSLB applicants and licensed contractors provide a valid email address when applying or renewing the license. Makes sense. But so the CSLB is now finally coming to the modern world. We're making people provide email addresses. And it's interesting. We review a lot of contracts and we help clients with contracts. And it's amazing to me how many contracts still say that notice can be done by facsimile and by certified or US mail. It's like, who uses faxes? Nobody. So how about we change everything to email now with a read receipt? So it's just amazing to me that a lot of folks are still behind the times. So congratulations to the CSLB for finally requiring people to provide email addresses.
Okay, well, if you thought those laws were exciting, wait till you get loaded in the next one. All right.
No. Oh, we have a question?
Yes.
Oh my goodness.
Come through from our online audience.
Wow.
I didn't hear the owl though.
No. We are a plumbing subcontractor. We subcontract trenching contractors. I don't know, but don't imagine that a trench contractor has to have a plumbing contractor's license.
Yeah, I don't think they do. I think it's so long, they have to have the proper licensure for that specialty work with the employees. So it's not that they actually have to have this. If you're subcontracting your plumbing work, then it would have to be a plumber with the right licensure. If you're subcontracting to a trenching sub, then they're going to have that proper licensure. Yeah.
Thank you.
Okay. Next law, we're talking about SB 601. And now we're moving into, at least for this, the Business and Professions Code. And this is applicable to home improvement contracts. So for any of the contractors out there who are actively working on residential construction, or anyone here have a house, homeowner? Okay, anytime that you have construction work that's done on your house, the contract that you sign should comply with the Business and Professions Code. And under 7159, and there's a number of other statutes in that area, have a significant number of requirements with respect to what has to be in the contract, as well as how the contractor actually performs work on residential construction projects. Very different than the commercial side. For instance, down payments on residential projects are limited to either $1,000 or 10% of the value of the contract, whichever is less. So I think all of us, even as lawyers, we have work done around our house, and we'll get a contractor says, here you go, here, I'll take my 30% payment now. So a lot of contractors who don't follow it or don't really understand, hey, we have this entire structure and body of laws that applies. So just outside of perhaps your working efforts, those and your personal efforts for your own homes, when you have homeowner contracts, just know that under the Business and Professions Code, there's a whole statutory umbrella that applies as protections for you. What this law does is it makes a tweak or a modification to the penalties that apply to a contractor who violates those provisions. And they can violate the provisions by not providing a contract that's fully compliant with Business and Professions Code, or they have conduct that's not in accordance with what statutes require. And generally under the statute, I believe penalties were between $100 and $5,000, depending on the severity of what the contractor did. CSLB determines the penalty. What this modification of the law does is it requires the penalty to be the full $5,000 per occurrence, to the extent that the homeowner contract is in a natural disaster area. So primarily fires, and contractors who came and take advantage of homeowners who were in a very sensitive state at the time they're signing those contracts. So again, for those of you who didn't know, the home improvement contract section, something certainly should look at.
Yeah, and I'm going to add to that real quick. So it's not only just penalties in the CSLB. You have to be very careful on that contract, because there is some case law that says if you don't have all the requirements, the contract may be deemed to be illegal or void. And then that opens up Pandora's box as to what damages could be against you. We as construction lawyers have had those cases. So you could get hit both ways. So if you're doing the work, you got to make sure you're careful.
And depending on the severity of what the violation is on the Home Improvement Construction Act, that could also lead potentially to disbarment of a license. So again, something to be wary of.
Okay, we got a question?
Yes.
All right.
For SB 601, any limits on the timing of invoicing for materials or mobilization?
So within these contracts, you're supposed to have progress payments outlined, and the payment structure is actually a box in the form. You're supposed to identify how that's supposed to be performed. And so there are limitations on down payments, and there are limitations on the amounts that people can get, but you have to have it spelled out at the beginning as to what they can get.
Right. And to the extent there are any questions, just shoot us an email and we can forward you the statutes, which have all the content. It's literally just section by section. Here's everything that has to be in the contract, as Ken said. They actually have a box and an example about how the payments are structured.
Thank you.
Okay, AB 43, and we're going to talk very briefly about a series of some environmental laws that have been implemented in the last legislative session. So first one, AB 43, it stems from the California Global Warming Solutions Act of 2006.
You guys know that act?
Yes. So most important thing for us, of course, is we got to combat global warming. Don't need to worry about homelessness. We got to deal with global warming. So what this bill requires is that the State Air Resources Board, they have to take certain measurements and create a framework in order to reduce what they call carbon intensity. And you say, what's carbon intensity? Well, that's actually the measurement of pollution. What it is, it tells you how clean the energy is that you're receiving. So for each kilowatt of electricity that's produced, how much carbon dioxide and other contaminants are actually released to make that. So State Air Resources Board has this very complex tracking system. Good luck anybody trying to understand or explain what it is, but they actually track the carbon intensity. And what they are doing with this amendment to a series of statutes is to layer in what they're calling a carbon trading system, which, as you can probably imagine, it's a way for contractors to essentially use credits to buy the ability to increase what their carbon footprint or carbon intensity is for not only materials they're using, but also manufacturers for what they're making. Not very clear at this point how that's going to be applied. Everything now is still sent to the State Air Resources Board to make determinations, but just know that State Air Resources Board, State of California is actively looking at how are we going to make our contractors and make our manufacturers have a smaller carbon footprint. And if you can't do it, they're going to make you pay for what your products are.
Yeah, it was interesting that the new laws for this year, we already went through the license laws. Most of them deal with environmental and climate change issues and affordable housing. So that really seems to be the legislature's focus right now, is how do we get more homes on more lots and make it easier for folks to build ADUs and stuff that's really been progressing the last couple of years. And then obviously all of the environmental and climate change laws. That seemed to be the focus. But again, some of these things aren't going to really take effect for some years. They're really starting the process.
The question, do material only orders follow the same requirement under section 7159.5, down payment no more than $1,000 or 10% of the contract?
So if somebody is, no construction?
I'm not sure.
Yeah, I mean that limitation is going to apply to any material orders on the home improvement contract. So if you're buying $5,000 worth of cabinets, there's going to be still a limitation on down payment of 1,000 or 10%.
And just know that the CSLB they're going, if there's ever a gray area or question, they're going to side on homeowner protection there. So to the extent that that there's a question, does it apply? Certainly you can have council look at it, but if it's a gray area, the CSLB is going to say that it does.
Yeah, and it's something else too, is you can send a request to CSLB for their advice. It's not necessarily going to be binding in court, but if you have a question, what am I supposed to do? How do you apply this? You can send it, and typically the registrar of the CSLB is supposed to respond back to you and say, yeah, this is how we would interpret it, or this is what you can do. Take that paper, put it in your file. So if things are not clear, you can't get some guidance, because sometimes you would ask the lawyers and we say, well, here's our interpretation, but it's up to the CSLB or up to a court.
Okay. And real quick, I'll run through a couple other environmental statutory changes that came out within the last legislative session. Next is SB 48, the Building Energy Savings Act. Essentially, we have now another commission in the state of California, the Energy Commission, which has been around. But what this bill does is essentially recognizes that one of the Energy Commission's obligations is to take from building owners money, of course, but also take from them information regarding energy consumption and usage. And obviously that is a pretty big hurdle for a lot of building owners, depending on type of building, size of the building, and its use. And what this bill does is it structures it a little bit while that information is still being collected. It confirms that commercial buildings that are less than 50,000 square feet don't have to provide the same level of information. So really just kind of fine tuning what the requirements are. SB 355, another environmental legislative change in the past session. This is regarding multifamily affordable housing solar roofing program, which is an entire mouthful. It's essentially an incentive program, a subsidy program for solar roofs. And what this law does is it essentially extends the application of the program. Previously, it would only apply, if properties, I think, have 60, what was the prior law? 60% of the units would have, 80% of the units would have income below 60%. get those numbers straight. So basically, it's tying the number of units in a new multifamily project to the income restrictions. And what this does now says, okay, well, how about we'll reduce it so only 66% of the units can qualify, and that, but they have to have below 80% of the median income. So it's really kind of lowering the threshold on one hand for the number of units, raising it for making them, at least in the eyes of the state, more affordable.
Seems like they flipped it.
Yeah,
They kind of flipped the percentages, so I know that's based on experience, but nonetheless.
Yep. Now, out of environmental, finally, and this one is a bit interesting. So now we're in public works. This is AB 1433, an amendment of public contract code section. Prior law, there are various projects, school district projects that, depending on funding, required the school district, the owner, to pre-qualify general contractors and essentially the MEP trades as well. That law has been expanded so that now school districts, when they have projects that are using over $1 million in general fund money or bond funds, all of those projects now are going to be subject to essentially pre-qual procedures through the school district. Those are set out in that public contract code section.
All right, conflict of interest laws. How many of you know about lease-leaseback projects? So, all right. So lease-leaseback projects are used by school districts, and it's a funding mechanism where they basically lease a project to a contractor who then leases it back. And it's a special funding mechanism. The contractor helps to then finance the project. It's complicated, but what came out of it, and we are going to talk about a case law later, which relates to lease-leaseback projects. But what came out of that was all these conflict of interest issues where people were on the front end of a project helping the school districts design, do pre-con work. Then they were getting the contracts and they basically kind of steering it towards themselves. And so there was a lot, again, we'll talk about that case later. But what's happened now is it's kind of brought these conflict of interest laws now to the forefront for public entities. And the typical conflict of interest laws found in the government code section, it's actually 1090 is the main statute. And this law, AB 334, adds a new statute, 1097.6. And what this allows now is somebody who is an independent contractor, Aaron, Mr. Employment Lawyer, but what is an independent contractor? In California, we know that is a very interesting question with all the changes in the laws in the last 5 to 6 years, but that this law now allows us, a public agency can hire an independent contractor to help them with pre-con work, and they're not precluded then from doing follow-on work, as long as they're an independent contractor, and there's protections for those people. So this is mostly going to be design professionals, consultants, and folks that are going to help in the front end, but still can get follow-on work on the project once the project is let. Can also apply to contractors. So I think what the legislature looked at said, this conflict of interest stuff is complicated. The independent contractor stuff is complicated, but we're going to give public agencies an opportunity to use the right people to help them plan and then implement their projects. And that's important. And again, the key is you want the right people and you want these projects to be well constructed and well designed. So again, but again, what does it mean? How's it going to be applied? That's to be determined. So anyway, this one, I don't think it's going to apply to a lot of people here unless you guys are doing pre-con work on public agency projects. So it's something to keep in mind, but this is a trend. I think it's a good trend. I think because we've seen nasty lawsuits, especially taxpayer lawsuits, going after people and going after public agencies saying conflicts of interest. You guys are doing something wrong and we're going to try to deem this contract illegal because of it. So I think the legislature realized we got to give folks a little more flexibility here if they plan their projects. So in our world, this is actually a pretty significant change.
Yeah, absolutely, because unfortunately, in the as Ken said, in our world on the litigation front, by the time a conflict of issue bubbles up to the surface, most of the time the project is well underway perhaps half done, if not more. So then at that point, you have, significant issues about project potentially stopping. If a contract is deemed invalid or illegal, what happens to payments that are made? Everyone loses in that instance. The kids who need to get the new classrooms and the new facilities, contractor who now has to write a check back, public entity is now mired in litigation. So this is hopefully a way to at least avoid some of that. Unfortunately, we've been involved in some of those matters, and at the end of the day, no one wins on those.
And these taxpayer lawsuits that challenge these projects are usually by NIMBYs. So people, not in my backyard, you don't want a school in your neighborhood. Okay, so be it. Okay, there's also some new laws that have to do with, so there's SB 706, progressive design build process. Have any of you worked on progressive design build projects? So this is a growing trend. And there's special contract forms that now actually are progressive design build. And basically what it is contractors going to be involved in the beginning and with the owner entity, and they're going to be there every step along the way on the design build process. And what we found is progressive design build creates more of a team framework. It's a collaborative process, less lawsuits, because ultimately, what's design build? Design build is that the contractor has designers under their own contract. So they can't come back to the owner and say, your design was wrong, here's my claim. And the progressive side is that these different steps, they're working in making sure the design is complete, and then they're working on pricing. And so it's really, personally, I think it's a good way to build. And I think that it really does allow for accurate pricing, better design. And I know that the contractors who are involved in progressive design build love it because they have their team and they feel like they have more buy-in from the owner from the get-go. So what this change to the public contract adds to the public contract code is it allows cities, counties, special districts now to use progressive design build for up to 10 public works projects in a year in excess of 5 billion. It used to be 5 projects. So now this is expanding design build, progressive design build for public entities.
I think that's more and more of a trend that I think we're seeing in the law is just an evolution of an expansion of design build and design build allowances now for smaller counties, smaller entities to use them, special districts, smaller projects. Used to be larger thresholds. It's getting smaller and smaller because I think a lot of public entities are getting now pushing back on your more traditional low bid design bid build project where they get an out of town contractor from LA who's coming to Chico on a project that may not from the owner's perspective may not understand the nuances in the market or the project, or may just come in to try to buy work to get a toehold in the area, and they end up having significant disputes and quality issues. So this is a way for owners to take a little more ownership, if you will, of their own projects by having more of a relationship with the entire project team moving forward.
But I have to say, it does create a little bit of the haves and have-nots. So if you get in and you get in good with an owner, now they have criteria. They usually have RFPs. They have to select somebody, and they can't just pick somebody that they love. There is criteria, but for the most part, those that get in are the haves that get these types of projects tend to do pretty well. And so there's a little bit of a barrier to entry in that regard. And then SB 617 is very similar. It just expands the right to do progressive design build to other type of entities, transit districts, municipal operators, joint power authority. So again, the trend, we're expanding progressive design build to public entities.
Well, that makes sense. What do you know?
I like it. I mean, I think it works for a lot of projects.
Okay. Any more laws to talk about? Next one, AB 587. I'm sure everyone in this room is aware. Contractors and subs of all tiers on public work projects, you have to keep certified payroll records. This law makes a modification to Labor Code 1776 that essentially requires when there's a request for payroll information from a union trust fund, essentially, that the information provided in response to the Union Trust Fund has to be either the actual certified payroll records on the DIR forms, or all of the information provided on the forms has to be provided, and an electronic copy of those documents aren't going to suffice. So it has to be the actual certified payroll document itself. So obviously this is some union legislation from the standpoint. I think there were concerns that the trust funds may not have been, the union funds may not have been getting all of the information when they're doing audits that they wanted. So this again is yet another step, another requirement on the contractor side that to the extent there's a request that information's got to be provided in a particular form.
You can read all the words of this line.
Yes. And I'll synthesize quickly. So the last two laws we're talking about, both, as Ken mentioned before, affordable housing issues, which kind of go hand in hand. I think environmental on one side, and then looking at affordable housing and barriers to developers to move forward with affordable housing projects. So boiling down SB 423, which does quite a bit, but I think essentially the intent here is to streamline the ability of developers to push forward with an affordable housing process, and it streamlines what the application process is. So essentially, to the extent that there are, a developer agrees that there's going to be land use restrictions on a development that provides that the housing unit restrictions are going to be maintained for a certain duration or certain period of time, that essentially, as long as there's not a conditional use permit that has to be addressed, that that approval can move forward. What this bill does is to clarify that the Department of General Services can step in and issue that approval in lieu of the local government or the local municipality to expedite the process. So, and again, this is probably a little bit of special interest legislation, but essentially to the extent you may have a public entity, municipality, maybe some smaller cities that either may be slower on making decisions or for whatever reason are pushing a project to go through the discretionary review process. This expands the law to allow a developer to say, hey, Department of General Services, you can step in and approve this for me. Not sure exactly how prevalent this is going to be, because many development projects have conditional use permit issues that are attached to them that have to be addressed through the local government entity. But if not, this at least provides a little bit of a faster track for developers to move forward.
And the question is, how quickly would DGS act? That's the state. So who knows? Probably not fast.
Exactly. And then the last bill we'll talk about also on affordable housing, which is SB 684. And again, another effort to try to streamline affordable housing. Under this bill, essentially, it allows the local jurisdiction to actually requires local jurisdiction to what we'll call ministerially approve, which is that if certain conditions are met that have to be approved, a parcel map or a tentative map that has certain restrictions conditioned on it regarding the number of residential units and the location of the land that for the parcel or the tentative map. And what this bill is essentially intended to do is to promote affordable housing in infill projects in urban areas. So what it's looking to do is to streamline the process for a developer to be able to develop a project in cities where you have a small parcel, a small footprint that's already around a developed area. Could be redevelopment as well. And again, I think this is just an attempt at least to make the process a little more friendly for developers who've had some issues over time when you have, Ken mentioned NIMBYs, but you have a lot of competing interests on infill projects. areas, whether you have areas that may be gentrified, you may have areas where people want to see a different use moving forward, allows the developers to, if their intent is to build affordable housing, to be able to expedite that process.
So those are the big people change and the laws for this year. So how many really apply to you guys? If you're doing a license renewal, perhaps, workers' comp, yeah, that could apply to you.
Project.
If you're building school projects or you're going to do progressive design build, for sure, that's going to impact you. But I think we went through all the laws and said, man, there's not a lot that's really going to apply to a lot of our clients, which again, like Scott indicated, that's probably a good thing, right? Because every year they have layers and layers and layers upon contractors to change the rules of the road a little bit. And so, like I said, there's some years that there are substantial changes. This is a good year. We'll take it. Who knows what 2024 is going to look like?
Okay, so we picked just a couple of cases we thought may have some general significance, and then we're also going to talk about the litigation change with respect to disclosures. First case, Suffolk Construction versus LAUSD. It's an interesting case, especially for those that in here that may work on projects where you actually have performance specifications on public work projects. So essentially, in the Suffolk case, Suffolk entered into a contract with LA Unified and to build a new school facility. And the contract provided that the concrete foundation for the school was to meet a performance spec. So essentially, it said, "Hey, contractor, you have to have this much in air entrainment. You have to have this. This has to be the curing strength in a certain number of days." And just said, "Hey, this is what you've got to meet, and we don't care how you do it." And of course, Suffolk poured the concrete, and what happens? It cracks, it fails, and they embark on this dispute between whether this is a design issue, whether this is a construction issue. Suffolk sued LA Unified, saying, "Hey, we've been delayed, we've been impacted. We're not your designers, and you owe us millions of dollars because of all of these impacts to us." And what they relied on is Section Public Contract Code 1104. And it's one, I think, near and dear to our hearts.
We love it for contractors.
Exactly. And if you have ever heard the phrase before that a public entity cannot require a contractor to assume responsibility for the adequacy of the public entity's plans, that's where that statement comes from. Section 1104 of the Public Contract Code. And Suffolk, as we would have as well, said, "Look, you violated 1104. This, we're not your designers." The court had a little different interpretation, and essentially said that 1104 does not apply in a situation where a public entity is incorporating a performance standard, even in a design bid build contract. In other words, not in a design build contract. And the reason being is that they're saying that the performance standard gave you criteria that a contractor could use its expertise and experience to achieve. The public entity wasn't saying we're holding you responsible for the design. Arguable if that's correct or not, but at least that's the line that the court drew. So I think the takeaways from that for those on public work projects is that if there's a performance specification, whether it may be for paint, maybe for certain finishes, obviously concrete work, or other work where you're directed to meet certain criteria but not told to do it, that very well may be appropriate and allowed. However, each instance, and why we have jobs as litigators, depends on the facts. Because, for instance, if you have, again, a performance specification for concrete work, yet all of the performance criteria aren't included, or you have conflicting criteria, then you very well may have an 1104 issue where the public entity is saying, "Contractor, we're holding you responsible for the design." So clarifies things a little bit moving forward, but it still is going to be a factual issue. So to the extent you are working on contracts, public work contracts that do have performance criteria, got to make sure that the performance criteria, you understand them, that they're reasonable, they're not inconsistent, and if they are, got to raise those issues early.
Yeah, and so 1104 is also what we call the implied warranty, fitness of the plan specifications. You're supposed to use a contractor to rely upon it, but we've always dealt with performance criteria. And we know these plans or the specs are not always coordinated. You know, sometimes it's boilerplate versus specific for a project. So this raises real concerns. And two other commentaries. Have you guys ever done work for Los Angeles Unified School District? Don't do it.
Or call us before you do.
Stay north, stay north. We've got clients go down there and it always ends up in litigation. That's a side note. And I think this is another example of why a lot of public agencies are going towards design build. Because in the design build process, especially progressive design build, you kind of work through these issues. And there's no questions that the contractor knows, because the contractor is responsible for the design, what is the criteria and what's approved by the owners. Because 1104 is the code section that, how many times have you cited it's gotten claims or lawsuits? 1,000 times, right? Every contractor says the plans and specs are not coordinated, they're not constructible, and they're ambiguous. This case definitely raises concerns on the on the contractor side. We do represent owners, but on the contractor side, I'm concerned about this case.
Absolutely, and I think, practically then you still have issues with respect to routing, for instance. Let's say you're doing a remodel project and you may or may not have accurate as-built if the initial work was done, many, many decades ago. If a owner provides conduit routing that it is not necessarily accurate based on the as-built, but they put a note in the plan that this is a performance spec and contractor, you're responsible for the routing, or if it's piping, conduit, whatever it may be. And if as contractor, you may not be able to access and, in the pre-construction or pre-bid phase, be able to look at everything, who's responsible for that? So you're still going to have this tension and these issues with respect to whether this is a performance spec or whether this is an incomplete design. So SUC doesn't necessarily answer that, and that's an issue we see on a lot of cases.
Okay, well, I did say half an hour ago, we talked about leaseback projects, and this is a case called Davis versus Fresno Unified. This is the third appellate case out of this project. And it flowed from an initial lawsuit was conflict of interest, where the contractor had actually kind of self-dealt for themselves. They were on the pre-con, and then the project was awarded to them. So the laws changed because of that case, and that was 9-10 years ago. And they did change the leaseback laws to kind of to prohibit that type of action and also to separate pre-con work from construction work. There was a second lawsuit, and now a third. And this one is pretty narrow in focus, and it talks about that the leaseback contracts, they focus on the debt financing, bond money, and whether that has an impact in terms of what challenges can be made. And the court held that the contract was incapable of validation and remanded on a taxpayer challenge, and that they could still seek disgorgement. And so what happens here is when you have a leaseback project, you can go to the court and say, is this a valid contract? That's a validation process. When people attack a leaseback contract for being illegal, they file what we call reverse validation. We're asking the court to say it's not valid. And there are some lawyers in the state of California that this has now become their niche practice. So we know a few of them. There's the lawyer who now, this is his third case, is in San Diego, and he just loves to go after Fresno Unified. So we've only seen a few of these up here. We do have one that's in this area, but for the most part, they haven't really come to the Sacramento region, which is good. They've kind of left some of the districts alone, but that doesn't mean they're not going to happen. So again, if you're doing leaseback, which can be very good work, be very lucrative work. This is just another case that you have to keep in mind in terms of whether or not they can challenge the contract. All right. This is a big change for us as litigators, which is now the addition of California Code of Civil Procedure Section 2016.090. So typically in, how many of you have been involved in litigation? If you don't want to raise your hand, okay? So in litigation, there are things that we call discovery, and that could be written discovery, that can be depositions, but most of the time it's the written discoveries. We can ask interrogatories, we can ask requests for admissions, we can ask for production of documents. There's all sorts of things that we do in litigation to try to discover facts from the other side, get the other side to admit things. And that is done on your timing. You send it, and you have to respond within 30 days of legal extensions all the time. So that's typically how California litigation has gone. You send discovery when you want to send discovery. Some people do it out of the gate, some people wait. You can do multiple sets of discovery, but it's how we try to figure out the position of the case. In federal cases, there's a rule of 26A, which is within a certain time frame, pretty soon after cases are filed, the parties have to do disclosures. So it's not a matter of waiting until you get something from a request from the other side. You have to do mandatory disclosures, witnesses, documents, information. So it really speeds up the process. And so when you file a case or somebody files a case against you, you got to get ready. You got to get your stuff together because you're going to have to do these mandatory disclosures. So in one sense, under the federal case law or in the federal rules, you know when you file the case, you tell your client, we got to get going. We can't wait. And so it makes you do your work early and it makes the clients do the work early. In California cases, you typically kind of wait until you got something from the other side. Now we have a change. And this statute basically is going to be similar to the federal rule. That there's a case filed after January 1st, 2024. So we're not talking about existing cases prior. The other side now can demand these initial disclosures within 60 days. And these disclosures, which are on these slides, are kind of similar to the federal disclosures.
Yeah, let chime in on a couple things. So as Ken said, so we're talking about, you've got two tracks. You got federal court, you got state court. So we're talking about state court in California now. So the intent is really in California to attempt to make things a little more consistent with federal court. But why this is important and we wanted to flag this is because obviously sometimes you get sucked into and drug into a litigation and through no fault or desire of your own, but there you are. So what this requirement is you get a demand on the front end, immediately after litigation is filed. And what it, boiling it down, what this means, you have to provide the names of witnesses and you have to provide all of the documents that are relevant to the issues. And if you take a step back, Rule 26, let me get the exact language, requires that the disclosing party discloses documents to witnesses and may use to support its claims or defenses. Okay, it's a little more finite because it's only looking at your side. What this change does in California is it essentially requires a party to identify all witnesses and all documents, including those that may be used by the other side adverse to you. So they're essentially asking you at the start of a case to disclose everything that you know, that's the good and the bad. And the fact that you may not have fully evaluated issues or fully evaluated the case doesn't make any difference. You just have to be able to throw all this out there. So, if you're on the defense side, obviously it's a requirement. You got to comply with it to the best you can. If you're on the plaintiff side, if you're filing an action, if you have a mechanics lien, for instance, and you're trying to collect, you need to know that not only do you have to now, pay your lawyers to, get the complaint in place and to move forward, you now internally have to have the resources in place to essentially provide all of your emails, all of your documents, and everything that's going to support what your claims are. And to the extent that It's not a complete disclosure. The other side can go into court and get sanctions, and that sanctions against the party or the lawyer or both. So I think it's $1,000 is the amount, but I mean, obviously you don't want court sanctioning you right out of the gate. That doesn't necessarily help the cause, so to speak, moving forward. So you got to keep in mind when you're let's say you got a $50,000, mechanics lien that you want to pursue. Not only you need to do that, you got to be able to essentially almost at the same time, shortly after, be able to produce, all the documents, identify everyone who has any knowledge of or that's going to be relevant to the issues. So it's may not seem like a huge change, but I think in practice it is going to be. Yeah. And if you're involved in a very large matter, if you're a general contractor on a significant project, stop and think about the millions and millions of documents on the project that you have. If you have someone on the other side who is not going to be congenial to work with, they can hold your feet to the fire on that. And it's there's going to be a lot of skirmishes, I think, and a lot of disputes that are going to arise out of it. But I think for those in this room, just know that when litigation starts and your attorney calls and says, "Hey, we need this information," we got to get it.
Scott Woodward, not throwing something in, then excluded if you miss the 60 days. Like, hey, we found this this filing from this date or whatever. We didn't notice it till now.
Yeah,
Mother may have.
That's always going to happen. Obviously everything is going to be fact specific. Best advice when those things happen through discovery, you learn about additional documents. You just got to provide them promptly. But I think that where the court's really going to hammer parties is if you're a general contractor on a large school district project and you're suing the owner for payments that haven't been made, and you have lots of change order disputes, and your initial disclosure is 100 pages, and all you're providing is the last pay application says here you go. A court's not going to look fondly on that. So it's really it's a weighing, it's a balancing, Greg, about how much you should be able to provide versus kind of the realities. But I think the court's going to err on saying provide everything.
Yeah, and hopefully you have lawyers on the other side to get along with, and you can agree. Maybe we won't get this done in 60 days. Maybe it's going to take us a little bit longer. And I think you might stipulate.
Yeah.
Okay. I think that's the end of the construction law update. So, you scary guys, nothing too scary. Well, this is a little scary for the lawyers. This gets our heart beating. So, why don't we take a couple minutes, stretch, and then learn about fun stuff on the employment side.
Go ahead and get started with the second portion of the presentation today on employment and the labor law updates for the beautiful state of California. There's lots of goodies in this one. Presenting today will be Aaron Silva. Aaron's a partner with the Labor and Employment Law Practice Team at Murphy Austin. He has an extensive background defending employers for state and federal courts and several administrative boards, including the National Labor Relations Board, the California Division of Labor Standards Enforcement, the California Workers' Compensation Appeals Board, California Unemployment Insurance Appeals Board, and Cal OSHA Appeals Board. Lots of boards. And if you don't, I encourage you to subscribe to his podcasts. They are short, informative, and always a wealth of information. So without further ado, Aaron Silva.
Yeah, lots of work. Good morning, everyone. So just so I know, where is the camera so I can? Oh, yeah. Good morning, everyone. So not a lot of new stuff in construction as far as laws. I would say with employment law, it's a little bit more mixed. It's not the worst year in the world, but it's certainly, there's a lot of action items that are out there, specifically as far as policies, handbooks, new plans, stuff like that. So we'll go ahead and jump into it. I like doing questions as is. We roughly got an hour, so you can do an ask me anything type thing. We can expand on concepts here, because there's lots of stuff that are going on in employment law that's not necessarily just focused on one particular case or the one law or set of regulations, whatever it is. So please feel free to ask as we go. So let's jump into it. Wage and hour issues, this is usually the most popular thing that exists in employment law, certainly in the last 10 years. And that continues to be the same. Like almost every single year, we have a new minimum wage going into effect. So it's going up to $16 an hour. There used to be two different roads that we have for smaller employers and for bigger employers where the minimum wage was increasing at different rates. That's not necessarily the case anymore. So we're now at $16 an hour. So for some of you, that will affect you just straight up because you have minimum wage workers. But for other folks, it still affects you even if you don't have minimum wage workers. And why is that? Because there's lots of things in California that are directly tied to the minimum wage. So the biggest one is exempt employees. So to be an exempt employee, there are certain requirements that exist. And one of them, and the most popular known one, is about you need to make a certain salary amount. Now, being an exempt employee is more than just that, but that's the biggest or the easiest factor to calculate. And so what it is in California is for almost all exempt employees, they need to make more than 2 times the state's minimum wage on a monthly basis. So obviously, when the minimum wage goes up, what's 2 times the state's minimum wage on a monthly basis? That amount goes up as well. So we're roughly looking at $16 an hour, where your exempt employees need to make, you know, $66,500 and change for the year. That breaks down to about a little over $5,500 a month. So if you don't have employees that are hitting that threshold, you're going to want to adjust their salary to make sure that that actually is the case, and then of course make sure that they satisfy all of the other requirements for exempt status. Now there are other things. If you're a unionized employer, there's lots of exemptions that potentially apply to you in California for things like overtime, no arrest breaks, things along those lines. But usually there's a multi-factor test that you have to satisfy, and almost all of the exemptions in the collective bargaining agreement are usually your employees need to make more than 30% more than the state's minimum wage. That's generally how most of them are, not necessarily all of them. But again, it just shows that there are multiple things that are tied to the minimum wage. But the one that's going to have the most applicability is your exempt status. So let's talk about something where I see a tremendous amount of action when I get demand letters and in litigation, and that's the concept of reimbursement. So for a little bit of background, there's California Labor Code Section 2802. And that basically says that any business expense that your employees incur on your behalf needs to be reimbursed. It's an incredibly broad section. And over the years, especially as we went to more of a remote work type of atmosphere, what that means has expanded a lot. So it used to be when that law was around for years and years and years at the very beginning, pretty simple. You folks in the construction industry, you have one of your workers going to Home Depot or Lowe's on the way to a job site. Really, that's something that they're going to have to be reimbursed for. They go to your shop first, then they're going to go to the job site after that. That's travel time that needs to be reimbursed, right? So those were the basic things. And then as technology kicked in, the concept of reimbursement changed, and it got a lot more nuanced. So it started with cell phones. So really, the big push was back in 2012. In a case where this was still before we were really doing a lot of texting, or at least the facts of the case. It was a 2012 case, but actually the facts had developed years before. So here's the base facts. This was when it was just an unlimited minutes plan, right? So we had an employee who made several calls on behalf of their employer or to their employer, and they sued, claiming that they needed to be reimbursed for that expense. The employer came back and said, well, it's an unlimited minutes plan, right? So it didn't cost you anything. So it didn't matter if you used a phone that we gave you, if you used your own phone, it's unlimited minutes. It's $45 or $50, whatever it is. It's the same thing regardless of whether or not you were doing anything on our behalf. And of course, here in California, the court said, no, that's not the case. The standard is, employer, you need to go back and calculate what is the reasonable amount of time that is attributed to that cell phone bill that was dedicated to employer stuff. You need to compensate them for that. So you need to effectively take every employee's cell phone bill and figure out what's the reasonable amount of time or reasonable expense that was dedicated to you. Now here in California, and I love to say that to the owl, a lot of employers don't actually take every employer's cell phone bill and calculate on a monthly basis what it is. What I'm seeing most employers do is they give some sort of like monthly stipend or something along those lines. But that's an expansive concept, right? So where we've seen the technology go is it's gone away from phone calls with cell phones, but it's gone to texting. So you have your folks out in the field that are texting, asking questions about projects, where do I need to go next, things along those lines. But putting apps on the phones, particularly for tracking time. So if your employees are, there's some app where they're clocking in and clocking out, it's on their personal cell phone. It's an app that you gave them, that you paid for, but it's on their phone. You're using some of their data, so you need to compensate for that. So most employers are dealing with that concept by just giving a flat out stipend, right? So there's not a magic amount, it just needs to be at the end of the day. If it was ever challenged, it needs to be more than the reasonable amount attributed to that expense, right? So that's where the technology was taking us. And then we ran into COVID and people were going home. And that's where our first case is going to come up. So this involves a SiriusXM, the satellite radio company. But the facts are pretty straightforward. COVID, have to work from home. This employee was given a stipend. They were giving a credit card. They don't necessarily need a credit card, so don't worry about that if you can. But here's the important thing. They got the stipend, they got the credit card, but they were expressly told, hey, if the amount that you're getting, $100 a month or $50 a month, $20 a month, whatever it is, if you don't think that's enough to reimburse you for all of your expenses, let us know. We can talk about it, and then we can make adjustments, right? So what ended up happening is that this employee never made any sort of request for any sort of adjustment to that monthly amount. But they did sue at the end of the day saying, hey, I wasn't getting enough money. What I want you to look at is on that third bullet. So Al, focus on that. But look at the things. This is a person that's working from home. Look at what they're seeking reimbursement for, right? So they're seeking reimbursement for furniture, basic office supplies, a chair, a table, a laptop adapter, a printer, ink cartridges, copy paper, as well as increased utility costs at home internet service and increased use of personal cell phone, right? That's a pretty expensive list, right? But it's actually pretty accurate. That statute's pretty broad. So arguably they have an entitlement if they're incurring those expenses working at home for your benefit as the employer to get compensated for something. But I just want to make the point that that's a really expansive list. It's probably pretty accurate, right? So you can either take all of your, your employees' utility bills if they're working from home, the printer costs, ink costs, things along those lines, and give them an individualized check. Or what most employers do is they just give that monthly stipend. But getting back to the case, this is what they're suing for, right? So what ends up happening? Now this is up on appeal in the federal courts, but at the lowest level, the court said, you know what, the employer did what they needed to do. So they gave them the stipend, told the employee that here is effectively your ability to appeal if you don't think that you're getting enough money by letting us know, and you didn't. So as the court said, plaintiff did not avail herself of the opportunities provided to submit additional reimbursement requests beyond the regular stipend. So there was no way that SiriusXM could have known that her expenses exceeded the amount of the stipend that she was already receiving. So like I said, that's currently up on appeal on the Ninth Circuit. My hunch is that probably gets upheld, but I don't know. That's my hunch. Point being, this is an employer that did everything that they reasonably could have done outside of actually getting the monthly bills, right? But for me, the main thing was it wasn't just the monthly stipend, right? It was saying, hey, if you don't think you're getting enough, let us know. And publicizing that and letting folks know. So some employers do it where they're doing the monthly stipend and then every quarter or something, they'll reach out and say, hey, you feel like you're getting enough, give us an email, something along those lines. But that's the point. These folks did it right. Now there's another case I didn't put up here where it was an employer that it was actually IBM. Also here in California, they go remote, and they say the reason we went remote is because the governor ordered us to do that. So it wasn't our choice or our decision to make our employees work remote, so we don't have to reimburse for business expenses. That's not up here because that didn't result very well for them. All right, rounding, yes.
What about for employers if work from home or work remote is an option?
Yeah, so we don't have a direct case on that, right? So, but still, at the end of the day, my hunch is that they're still incurring some sort of expense on your behalf. So there is some case law that says that it's expenses that they were forced to incur, or words to that effect. We just don't have a case one way or the other that says that. So I still think until we have a case that says one way or another, I still think that monthly stipend is the safest way to go. So, but it's a good point. We'll see what happens. I'm sure we'll get there at some point. So rounding policies. So a lot of you folks in the construction industry use rounding policies for years and years and years. This was allowed, right? So someone gets to work a little bit early, so you don't necessarily pay them based on the exact minute that they get there. But you round it up, or maybe they get there a few minutes late, you round it back up to 8 o'clock or whatever it is. That's a rounding policy, right? So in 2012, there was a case called See's Candy that effectively said that those rounding policies were allowed. If more often than not, it equated out to, it didn't always cut against the employee. Sometimes it benefited them, and sometimes it didn't benefit them, right? There needed to be some equity in how the rounding policies were administered. So for years and years, since 2012, lots of cases cited See's Candy for that proposition, and it was allowed. But in the last year, we got a couple of cases that came out that basically said, if you're an employer that has the ability to track the exact amount of time that an employee is working, a rounding policy isn't going to be allowed. Now, that is done in conjunction with a lot of decisions that we've gotten in California that are taking away this concept that there's effectively just this de minimis amount of time that we don't compensate for. So if you've been to these seminars for the past few years, I've talked about these cases. One of them was a Starbucks case where, as a barista working at the till, clocks out at the till, and then walks over and locks the door on her or his way. I think it was a her, it was a female plaintiff, on the way out, right? So that time from clocking out to going to the door and locking the door wasn't compensated, right? Which was 30, yeah, you laugh about it, right? You wouldn't be laughing about it if you got sued and went to the Supreme Court. So what was the point? That's work time, right? Maybe it's a minute that day, but over the course, if they work, 20 days over the course of a month, that's 20 minutes, and then over the course of a year, that's a part of a utility bill or something along those lines. But the court was recognizing that, even down to the minute, you're going to need to be tracking time. Under federal law, that isn't necessarily the case. There's another popular back pattern out there for more white collar industries or employers where an employee walks in, they have to turn on their computer and then they clock in, right? And it's the same thing at the end of the day. They clock out and then they shut down their computer. Boot up time, boot down time. Do you need to compensate for that? The answer to that, right? Of course you do. That came out last year. How do you track that time? It's a huge struggle, right? But anyways, in that vein is what we have here. So those two cases that decided that so in California you have trial courts, intermediate court of appeal, and then you got the Supreme Court. So those were two intermediate court cases. They are on appeal to the U.S. or to the California Supreme Court, who is going to decide that issue. My strong hunch is that rounding policies are going to be invalidated if you have the ability to track exact amounts of time. And if you have some sort of tracking system in place, which you probably should, you probably have it. So I can't guarantee you that's what's going to happen, but that's what I think is going to happen, just based on what I've been seeing the California Supreme Court do for the last few years. So a lot of my slides are going to be about things that you need to do to your handbooks or new policies. If you have a rounding policy, when I'm reviewing them, I'm highlighting them, and I'm just, when I'm talking to my clients offline after I've done the review and I've done my changes, I say, I'm letting you keep it in here, but you're doing it at your own risk. I don't know where this is going to go, but you need to be very mindful. So if you had a great source of information that could give you pretty up-to-date analysis on what the Supreme Court does, say like there's a 5-minute month podcast that a local law firm provides, if you can subscribe to your card, that would be an excellent resource. Otherwise, you need to watch out yourself to see what the California Supreme Court does. But this is going to be a big thing for your industry in particular, because most of you folks do have the ability to track to the exact minute. Okay, employee sick leave. Okay, so Ken made a mistake in one of his slides, which is inexcusable. I do this presentation a lot, so I think this is like the 6th or 7th time I've done it since January. So I always modify it a little bit, but I have like a master slideshow, and then I modify it as needed. Sometimes I'll put in slides that I don't have for other things. So I did make a mistake here. There is one slide that I kept out, and a slide that I should have taken out, and one that I should have kept in. So I will read you when we get to that point, but effectively I left the slide out, so I apologize.
That's inexcusable.
Our amazing partners in the thing.
It's this kind of thing that keeps attorneys humble.
We are nothing.
becoming as complicated as the prevailing wage is, as far as I'm concerned, unless you use the upfront method, which we'll talk about in a little bit. But employee sick leave, paid sick leave. This is the thing that's the most popular topic when I do these presentations. I'm not going to make you do it, but I did do a presentation where I made the entire audience stand up and take an oath that they were going to limit their questions to less than 10 minutes. It was an oath that incorporated Elvis's taking care of business oath, which if you don't know, he had a Memphis Mafia. Those were all of his enablers, and he required them to take an oath. So I combined the two because I only had a few oath models, and then we used that, but I'm not going to make you do that. But just be mindful of the time on this one, because this is very popular. So where were we at with paid sick leave? So my slides, because we've got a lot of information here. So previously, employers had 3 options of providing employees with paid sick leave. And these were under the old rules where it was 3 days or 24 hours. Some of this stuff is going to carry over. But you could grant at least 24 hours or 3 days up front at the beginning of a calendar year, the anniversary year, things along those lines. That's the upfront method, front-loading method. That is the method that you should be using because it is the easiest. And I encourage everyone to do it. And when I revise handbooks and they have something that's different than this, I tell them, please change it. But this is the best method to do it. So you just give all the time up front, right? So the nice thing about this is the administrative aspect of it is very low. And you don't have to, there's no accrual or carryover into the next year. It's just say you're using January 1st, you get to December 1st and you got an employee that used 2 of their days, they got 1 day left. The next day, when the year resets, now it's back to 3 days or 24 hours, right? What's the downside to this? There is the possibility, and I've had some clients express this and they won't do it, that on January 1st, if that's the year that you're using, all of your workforce goes out in 3 days for paid sick leave, right? It's possible, I haven't seen it, but that's the only downside that I've heard about this one, right? And then obviously you're giving it upfront at the very beginning, so they haven't necessarily included as would apply to the other standards, but that's the upfront method. It's the best method. I highly encourage you to do that. The other way was to allow employees to accrue 1 hour of sick leave for every 30 hours work. That was the statutory accrual method. And then the third method was you could develop your own different accrual method, provided that it occurs on a regular basis. So throughout the entire year, right? It's not just something that exists for the first 3 months or the first 6 months. And the employee accrued at least 24 hours of sick leave by their 120th day of employment for the calendar year. And then in each 12-month period, they get the full amount, right? Then we go on, a little bit of background. For those that did do accrual methods, you could limit the amount of accrued sick leave an employee could use in each year of employment. In the 12-month period, so you can use a calendar year, their anniversary, whatever it was, but you could limit the amount that they actually use to 24 hours or 3 days. But if you're using an accrual method, one of the concepts, one of the downsides is that unused paid sick leave would carry over to a certain extent, but you cap that to 48 hours or 6 days. So you would want to have all that stuff in your handbook. So a lot of these concepts are going to carry over, right? Let me look at that. Because when we got the new law, which is SB 616, which took effect on January 1st, 2024, the major change that it did is that it increased the amount of paid sick leave that an employee gets from 3 days or 24 hours, whichever is greater, to 5 days or 40 hours. So that's the big overall change, right? And the legislature has been trying to do that for like, I think about 3 sessions at this point. But overall, that's the biggest change that we got. So here we are. There we go. So here we are, back to how can you actually get this paid sick leave, right? So you could do the number 1 option, which is the same option. It's number 1 for a reason on my list here. You upfront it, right? So you just give it to them at the beginning of the year, their anniversary date, whatever it might be. So January 1st, they get 40 hours or 5 days, right? 2, you could do the statutory method, once again, which is 1 hour of sick leave for every 30 hours worked, right? This is accrual, so it's got carryover requirements, right? Accrual requirements, things along those lines. And this is the slide that I didn't include. So now don't look at that. Let's do this. It's the third method, right? So so don't even look at that screen. Al, look someplace else for your wisdom and your guidance that you're going to give all the forest creatures when they come to you. But right now we're just going to focus on me and the slide that I eliminated. So the third is develop. You have your own accrual method, right? which is just like the old way. So I'm going to read you the slide. So you can have your own accrual method, provided that it occurs on a regular basis, right? And the employee accrues at least 24 hours of sick leave by the employee's 120th day of employment or the calendar year. And 40 hours of sick leave by the employee's 200th day of employment or the calendar year. So let's do that one more time. By the 120th day of employment or in the calendar year, they have to have at least 24 hours. And by the 200th day of employment per calendar year, they have to have 40 hours, right? So those are the rules that go into place if you're going to have your own accrual method. Now, what you will notice is with both probably your own accrual method and the 1 hour to 30 hours, you're probably going to exceed at the end of the day, depending on what your pay periods are, you're going to exceed the 5 days or 40 hours more than likely, right? So if that's the case, you still have cap rules and accrual rules, so you can limit the amount of accrued sick leave that an employee uses in a calendar year to 40 hours or 5 days, all right? Pretty consistent of what happened before, just the numbers are different, but you can also cap the amount. The cap has increased so that an employee could only accrue a maximum of 80 hours. But again, those are all things that need to go to your handbook if you're going to make those changes. So this is out of all the things we talked about, this is the number one thing where more than likely you need to do something affirmative right now if you already haven't. So into your handbook, your paid sick leave, you all should have some policy that addresses that. They're going to need to be adjusted. So hopefully you're just using, the number one, and you just have to change the numbers there from 3 days to 5 days or 24 hours to 40 hours. But for the accrual, obviously you are going to have to change the accrual amount potentially if you're going off that statutory amount of 1 hour to 30 hours work. But you're going to have to modify your accrual and your cap numbers as well. So point being, there's something that you need to do. And you need to do it because hopefully you put out your new handbook for the new year. If you haven't, I can help you out with that, but you should be doing that. So that is a very quick overview of a very complex topic, right? So I will just ask. Oh, there we go.
Well, I actually have a question that came through regarding reimbursement.
Oh, okay.
Although the company doesn't require employees to work from home, some may prefer to do so for a few days each week. In such cases, we can provide necessary equipment, including a laptop, monitors, and a docking station. Is it okay or to recommend establish a written agreement stating that the company isn't liable for any expenses incurred by the employee while working from home?
You're more than free to do that. It's enforceable. I don't think it will be, but yes, yeah. And quite honestly, so this is one of those things, we will now go on a tangent talking about remote work. Yeah, if you're going to do any sort of remote work type arrangement, you should have some sort of agreement in place with your employees anyways. If for any other reason that specifies that all of those workplace policies that apply as far as, taking meal breaks, reporting overtime, even if they get injured at home while they're on your dime, that's workers' comp potentially that they're going to require. So there usually should always be some sort of written agreement or a policy in place that addresses that. Now, if they're working from home and they're doing it voluntarily, I like those agreements to specifically say that because, again, I don't have a case one way or the other saying what happens with voluntary. So you could do that. At the end of the day, is it going to be enforceable? I don't know because I think, they're still using some of those utilities, right? That internet service presumably is being used for your benefit. That PG&E bill, a part of it is technically being used for your benefit, right? So we don't have a case one way or the other. But so employers, you get to decide what you're going to do in that situation. But regardless, you need to do some sort of agreement or some sort of policy that addresses that. So it's not a direct answer. My hunch is that it probably wouldn't eliminate all of your liability, but it certainly would be a good step, right? To at the very least say, hey, this was a voluntary thing. I would go so far in that agreement as to say at any time you have the ability to come back to our office, use our resources, something along those lines, just to really reaffirm the concept that this is voluntary on your end. Okay, anything else? There's not one page 60 question.
Everyone's going to do it up front. Is that right?
Everyone's going to do it up
Everyone's
front.
going to do it up front.
Yes, all right. Did you guys hear about the oath in advance? You didn't want to get.
Okay.
Oh.
Would you go by days worked like the work week, or would you go by payday when you're calculating the hours?
Oh, it's whichever greater, right? So if you had an employee that was working like 10-hour days, it's what, you know, is it the day amount or the hour amount that's going to be greater? So I think the examples given is someone that works 10-hour days, right? So they would either get 5 days or 40 hours, right? So which one is going to be greater for a person that's working 10-hour days, right? It's going to be the hours. So it's the day part that's bigger. So technically they're getting 50 hours of paid sick leave. So is that answering your question?
No,
Okay.
I think I've maybe phrased it incorrectly. So if you are trying to see what the balances are, like what hours the employees have used for the year, and you're putting it into your system to do a report, would you do it by basically the week ending date or the paycheck date?
Are you talking about when you pay them? I'm still not following the question.
If an employee accrues or uses 40 hours from the first of the year to December 31st,
Yeah.
there's that. But then what if you use your payday instead? Like there's two ways to calculate hours, whether it's the days worked or the paycheck date. Does that make sense? When you're running a report in your payroll system,
Yeah.
you can run it by the days they actually worked, like a time card history report, which would show days they were actually on site.
Right.
Or like a paycheck date, which would be like, hey, they're paid this Friday, it's only gonna pull hours by.
Well, I can tell you that the payrolls is that if someone takes paid sick leave now, you don't have to pay them until the next payday period, right? So you can
Yeah.
skip one. Is that getting close to where?
Yeah, that's,
Okay, all right. We can talk offline,
Okay.
because I don't know if I'm fully getting that question.
Okay.
But, all right, any other paid sick leave questions? Okay. Quiet. Okay. I know, there's the construction exemption to this thing, right?
I do have one question.
Okay,
Is there any valid reason we say they cannot use the sick day?
almost no.
No.
Almost no. So the labor commissioner says, well, straight up, you're not required to track the reason why someone takes their paid sick leave, right? And by the way, there's lots of reasons why someone can take their paid sick leave. So it's not only for, themselves for health reasons, but there's a laundry list of folks that they can take paid sick leave for as well, right? Their kids, parents. Last year, you all changed your handbooks to include a designated person, so they can take a paid sick leave to care for that person, whoever they designate with once every year. And then, of course, related to domestic violence, stalking victims, they can use their paid sick leave for that. But no, for the most part, you cannot ask them in advance for a certificate. Now, there is one question on the labor commissioner's FAQ section on paid sick leave that says, well, if it's obvious that an employee is trying to, or it applies that they're being fraudulent, you probably could ask, but they don't necessarily say what that is.
No.
So I guess if, an employee says that they were even taking paid sick leave and, Facebook or, social media, you got digital pictures, I guess you could ask in that situation, but I don't know. I mean, it's very vague, right? So I, kind of shy away from that to the extent that I can. But
Doesn't the state require a note after 3 consecutive days?
it doesn't require that, no. I know. And a lot of employers do that, but no, it's not required by the state. Or I should say for private employers, I don't know what it is if they're on the list. So, okay, that's paid sick leave. So let's talk about, yes.
So if the employer asks for it, can the employee say, no, I'm not going to give you enough?
Well, it depends what the circumstances are. So, yeah, I would think that an employee could say that, but unless it's very obvious, because that's the default rule, right? Is that you can't ask for the note anyways. So unless there's something, it's, hey, employee, here's, a picture of you in your mouse ears. I say that because I got sucked into going to Disney World 2 weeks ago. Now, my sister works for Disney World. It's like, oh, we'll take it for free. That's like $2,500 for a family of 4, right? But that doesn't mean that I don't still have nightmares about everyone in their matching shirts saying Disney World 2024, their mouse ears or their character shirts. That's still a little bit of but I would imagine that if you have the situation where you have, evidence that, hey, you said you were taking paid sick leave, it's very obvious that you weren't, that, yeah, you could demand that. But the default rule is that you can't. So I really think that would be on the circumstances. So that's the most black and white situation that I can think of. But just generally, it's just, oh, you said you were out on leave, right?
So you don't have to get a note from a doctor.
Correct. Right, because basically it's supposed to address situations where someone's just sick for a day, right?
Yeah.
And most people don't go to a doctor if they can dig it into their doctor, right? To do that.
Sick of work.
Right, exactly. Sick of work.
Heard that before.
Okay, all right, so let's talk about marijuana, cannabis, pot, whatever you want to call it. I know that there's an exception for you folks, but I don't necessarily know what the exception says. So let's talk about what the law does. So now here in California, it is effectively a cannabis use that is off the job and away from the work site is effectively protected. On top of that, you are not allowed during a drug screening to take an adverse employment action because, and I got a quote here, because of the presence of non-psychoactive cannabis metabolites in someone's hair, blood, urine, or other bodily fluids, right? So this is one of those handbook type changes. So this usually affects the laundry list of things you can't discriminate against people for. So I include cannabis use, but then I say to the extent required by California law, right? And why do I mention that for you folks? Because there are exemptions for employees that are in the building and construction trades. And of course, those that are required effectively by federal law or some sort of federal contract to do testing or to not allow people that have cannabis in their system on their job site. Here's my comment about the exception. This is the actual quote as it exists in the law. Quote, this section does not apply to an employee in the building and construction trades, unquote. I don't know if that applies to your white collar workers or the people that are in your office. I don't know if that's actually the people that are doing the trade work or if it's broader than that.
What if we represent contract?
Well,
So Aaron, someone's using cannabis because they have a back injury or whatever, and they're on the job swinging a hammer or what have you, they can be under the influence of a non-psychoactive or
no, it would be the
can be
opposite.
psychoactive,
It'd be the
psychoactive.
opposite. It'd be the opposite. The way that this reads is that an employee that is in the building and construction trades, this protection doesn't apply to them, right? The question is who's an employee in the building and construction trades? So this is where our worlds are going to bleed over. I mean, I have to imagine that term gets used in some sort of statute or regulation in your guys' role, but not necessarily in mine. So the way that I've been dealing with it with the construction clients that I have when I'm doing your handbooks is, so the laundry list has cannabis use that's off the job and away from the work site to the extent required by California law. And then I have a little bit of language about, it doesn't apply to an employee in the building and construction trades, or, I have my federal language. Because here's what the odd thing. That section is, I'm an employer, I can't discriminate against you because of your race, your sex, your gender. It's that laundry list, right? But it's like short terms. And then all of a sudden I have this huge chunk that's about cannabis use that's off the job and away from the work site that I have to expand upon because I don't necessarily know what it means. But that's the way I've been dealing with it for the construction folks. The other place that this is going to come in and change is your drug testing policies. Again, it's my policies for construction clients are saying to the extent required by California law, we will not take an adverse employment action because of the presence of these metabolites, right? So it's a little bit of, wordsmithing on my end to try to figure out some way that I can deal with this brand new law. But anyways, that's where that one is at. So we got something similar related to this. Scott, can you flip one?
You broke it.
I broke it.
Froze.
Tech support.
Yeah.
All right, Al. Al,
Al can't do that for you.
you're wise. No, why don't we just go over to our handouts at this point? So the next law that we have, somewhat related to it, but basically what it is that you cannot ask your applicants about their prior cannabis use before they start to review. This is a build-off of what's known as Ban the Box in California. So I think it was about 4 or 5 years ago at this point that California passed what's called the Ban the Box law, which basically says that you cannot ask your applicants about any sort of criminal history until you make a conditional offer of employment. And once you make a conditional offer of employment, then you can do some sort of background check to see if they have some sort of criminal history. But there's this extensive now regulatory stream that's got regulations on this last year about how do you deal with the situation when you actually get a hit about some sort of felony conviction, I should say, misdemeanors or arrest you can't do anything about for the most part, right? So here are some of the things that exist here in California. If you get a hit on someone having a felony, after you make a conditional offer of employment, you need to first do an individualized assessment about whether or not that affects the job or not. We got regulations, so I'm merging two things here. We have this law, but I'm merging it with another concept, the Ban-the-Box law. Got regulations from the California Civil Rights Department that used to be the Department of Fair Employment and Housing, very extensive. How do you do an individualized assessment? I think that department listed like 15 factors that you can take into consideration, right? But effectively, you need to figure out, you know, if someone was convicted of embezzlement, is that going to affect the way that they do their job as, you know, a blue collar worker for you? I mean, the example I always give is, you know, a school bus driver, if they were convicted of embezzlement, probably not going to affect the way that they do their job. Shouldn't probably be a reason to deny them employment. However, if it had to do with some sort of sexual assault, probably. So it just depends. That's the individualized assessment. But regardless, you do the individualized assessment, you got to notify the employee that, you know, we're tentatively not going to continue to employ you. Here's a copy of the report. Here's the felony we're talking about. Then you need to give them 5 business days to give you an explanation of what's going on. Once you get that, you need to consider it, and then you give a final notification to the employee. That includes whether or not they were disqualified, any appeal rights they may have. But here's always the kicker. Hey, employee, we're going to fire you or not hire you. Here is your way to sue us with the California Department of Civil Rights. So here's how you file a complaint against us. But anyways, bringing that all back to this slide, right? So you cannot ask applicants about their prior use of cannabis, which bleeds into that other law. And then if you find out about information about cannabis use or their criminal history, you can't necessarily use that against them unless you comply with all that ban-the-box stuff. So you got to go through that analysis to figure that out. So that's that one. Leaves of absence. We got last year, so not necessarily this year, bereavement leave was required. One of the questions that I got was, okay, so bereavement leave is now required. It's generally unpaid, although they can use their other benefits for it. Does bereavement leave cover a miscarriage? And I got that question like 3 or 4 times. Interesting question. Wasn't a clear answer. I tended to be conservative with the advice and say, yeah, let's just assume that it is. Well, this year we actually got a clarification. So you had a bereavement leave last year. We got a brand new type of bereavement leave. So this is not a build on from last year. This is something entirely separate. So this is one of those handbook things that you would do, right? So you'd have your bereavement section, and then you have your reproductive loss section right after. So this is one of those handbook changes things. So what's our basic requirements? Very similar to bereavement leave from last year. Employers with 5 or more employees must provide up to 5 unpaid days of leave following a reproductive loss event. The leave is unpaid, but the employee can use their existing PTO, paid sick leave, vacation, things along those lines. What's a reproductive loss event? Well, it's defined by the statute as the day or a multiple day event, the final day of a failed adoption, failed surrogacy, miscarriage, stillbirth, or an unsuccessful assisted reproduction, right? So it's a little bit more expansive than just a miscarriage. Now, here is the thing about reproductive loss leave. You can have multiple events within 1 year, which is where our last bullet point goes to. Reproductive loss leave can be limited to a maximum of 20 days within a 12-month period, right? So if someone had the unfortunate situation of suffering several miscarriages within 1 year, they would be entitled to this reproductive loss leave several times, or they had one of these other reasons, right? But it can be capped to 20 days. So this is one of those things that you're going to want to mention. Workplace safety. All right, so I think this group, if you've been here before, you know that I worked for OSHA for several years back when I was a law student. But still, I always consider it my home agency, so I'm always interested in what they're doing. So there's a long political story about how we got to this actual law. But effectively, Cal OSHA was supposed to adopt a bunch of regulations several years ago about workplace safety and things that employers needed to do. They didn't do it. So the legislature stepped in and said, standards boards, those are the OSHA people that come up with those regulations. You need to have these rules in place by, I think it's 2025. But in the meantime, employers while we're waiting for what the standards board is going to do, employers by mid-year this year, so it's July 1st of 2024, you need to come up with your own workplace violence prevention plan, right? So that is very, very small font there because there's lots of requirements about what needs to go into these things. But we'll just do a couple of highlights, let's say, right? So some of this stuff's gonna, this is really, really small, right? I'm 42 years old. If you haven't, I've noticed the additional gray hairs in the front. So as compared to last year, so, but the eyesight,
You're still young.
at heart. Not according to my 5 and 7. They asked me if I had a chance. My 5-year-old asked me yesterday, because he's really into George Washington, and George Washington's brother, Lawrence, died of tuberculosis. Right? So he's asking me what tuberculosis is, and for a guy that got a D in chemistry, I'm trying to explain it to him. And then he asked me, well, Daddy, you're older, and you get tuberculosis. All right, anyway, a lot of this stuff is very similar to an IIPP, right? Injury and illness prevention plan. So the names and job titles of those that are responsible for implementing the plan, procedures to obtain the active involvement of employees, trainings down here, procedure for ensuring compliance. You know, you can look at this, right? But this is going to be a really detailed prevention plan. I am hoping, and I was looking, you saw me looking at the computer when these guys were talking, I was seeing if Calosha put out their model plan yet. They have not. So I would imagine Murphy Austin, we've started to develop it, but it's probably going to take a couple more months. This is a lot of stuff, right? So, and how you do that is going to, you know, if any of you use the Calosha IIPP model, you know, basically you just check things off. I'm assuming that that's what they're going to do. But there's a lot of stuff that's in here. But I mean, if you look at the overall stuff, it's very similar, right? What are your procedures to prevent this from happening? Training, record keeping, all that sort of stuff. So in about, where was at this point, mid-February, in about 2 months, you need to really be focusing on this thing. So this is going to be its own plan, right? This is not something you just add to your handbook. And I don't think you add it to your IIPP. I think it's a standalone document, but it's going to be pretty big. So make sure you put this on your calendar, right? So you pay taxes in a couple months. I would, you know, calendar this thing as well, because this is very taxing. But anyways, this is the workplace violence prevention plan, the elements that need to go into the plan. But there's other components to this as well, as along with doing a maintenance or a incident log, right? So very familiar to your log 300s, right? Someone gets injured at work, you need to log that stuff, even if it's not necessarily reportable to OSHA. It's very similar with with workplace violence going forward. You're going to have an incident log. So it's going to have information like the date, time, and location of the incident. By the way, we're going to go through this list. Now, so this stuff can be really boring, right? But sometimes you read something and it just puts a little smile on your face and it's like, oh, that's a little weird, right? Let's see if you can guess what that is as we go through these elements, right? So the date, time, the location of the incident, and whatever. Detailed description of the incident, that's pretty standard. Classification of who committed the violence, I would expect so. Classification of the circumstances at the time of the incident, including whether the employee was completing usual job duties. Classification of the location of the violence incident, the type of incident, including whether it involved physical, verbal, sexual, or animal attacks. Okay, I understand what that's, right? But you got to enjoy your job sometimes, right? So I just imagine just like, you know, just a pack of holes or some sort of, you know, just something odd, you know, like the movie The Birds or something where they just attack something, but it's just like, I guess an animal attack would be workplace violence. So anyway, that raised my eyebrows. Okay, and then the consequences of the incident, such as medical treatment, law enforcement was called out, and the contact information for the individual completing the incident log. So this is stuff that you're going to need to keep. And actually, before we get there, so what do you need to do? So obviously, you're going to have to develop your own plan. But let's go through some of the to-do lists for workplace violence prevention plans. You need to create a plan. You need to make sure that's consistent with your IIPP. So there's elements in your IIPP about, you know, when you do inspections, training on this sort of stuff. you just need to make sure this all meshing together, right? So your IFP doesn't say one thing, and then your workplace violence prevention plan says something different, or something inconsistent. Of course, this is the big thing because people typically don't do this. You construction folks can be better about this, but training on this stuff. It is a requirement. It's an express requirement, so it has to actually go into the plan procedures and for developing and providing training on the plan. So it's a typical training, right? Someone first starts with you, you need to provide training on it, right? Just like all the other training you need to do, the safety training you need to do, the COVID training you still need to do, the sexual harassment training, all that sort of stuff, right? And then on an annual basis, you need to do it as well. And then keeping records, this is what you need to plan for as well. So generally, for training records, it's a year. For incident reports, it's a year. For hazards that you find, it's 5 years. So there's record keeping requirements here as well. So those are the steps that you can start thinking about, but they're going to become a lot more serious when you get closer to July 1st. So as we wrap up here, yes.
For construction trades and general contractors that are, does the statute describe what workplace is? I mean, if we have multiple job sites, are we going to have a separate plan for each job site?
Yeah. I mean, usually you can get away with, just like an IFP, right? So you don't necessarily need to have an IFP for every single job site. So I would imagine it's going to be the same. It's just one, workplace violence prevention plan that applies to all. And then obviously, if you feel the only way that you can implement it is through a separate one, then you can do that, right? But I mean, at the end of the day, I mean, a lot of this stuff is so incredibly broad, right? Procedures. A lot of that presumably would carry over from job site to job site. So there's a non-definite answer that I gave to your question. But
It was lawyerly.
Okay, we're almost done. Last slide. Workplace plans, prevention plans. So the legislature is very concerned about workplace violence, although they're effectively making criminal history a protected class in California. So in my mind, there's a conflict there, but whatever, it is what it is. So as of now, employers, a lot of people don't know this, but employers have the ability to get a restraining order on behalf of their employees. So usually it's a pretty high standard. I've done about 10 of these over the last, I think they're Murphy Austin. So I started the day after President's Day 2007. So how many years that is. And that time, I think I've done about 10 of these. But you can seek a restraining order when one of your employees has suffered unlawful violence or a credible threat of violence. So it's a pretty high threshold. You actually go into, if it's here in, one of the local Placer, or I'm primarily in Sacramento County when I do these, you actually do like a trial, like it's an administrative trial. So you put on people on the stand, right? If the person you're trying to get a restraining order is up there. So it was actually my first trial that was actually in front of a judge. So it's a little odd, but a lot of work, but pretty high standard. Well, that's not going to be the case starting in January 1st, 2025. So now employers can seek a restraining order for an employee who suffers harassment. So you go from credible threat of violence or actually suffered violence to just someone who's having suffering harassment. And I'm not diminishing, the severity of a harassment situation. I'm just saying that the two standards, I mean, one of them is very high, now it's, much more decreased. So what is harassment? It's defined as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, and that serves no legitimate purpose, right? So the standard is much higher. Not necessarily that you have to do it. It's not saying that. It's just saying that you can do it. And I've had employers that do it, right? Because usually you get a restraining order, and that's going for the person that's restrained. That usually prevents them from having firearms or coming within, I think it's usually like 200 yards of like the workplace or things along those lines, or where the employee is going. And sometimes you just have employees that are in unfortunate situations where they just don't have the resources, they don't have the ability, they don't have the know-how to go get a restraining order on their own. Right, so employers can go do this. So that can be, this can be a weapon in certain circumstances when that happens. So that's workplace violence, and with that, and with what are we, 1 minute to go? I'm doing this one. So if you're interested on the podcast, it's my podcast. I try to keep it around 5-6 minutes a month, and it's just whatever topic is significant. I think this last go around, I did a little bit more deeper dive into paid sick leave law. You got a much more extensive version of that. You know, and I can guarantee you, probably 2 months, I'll do the workplace violence stuff. It just depends. You know, it's a new case that came out, you know, something that's interesting. Or I get a lot of questions from clients, so I try to address it that way. So if you're interested, you can drop me your card. I'm more than happy to put you on that. And then that's the other way to get client alerts, to the extent that we do client alerts. So in COVID, we were doing them like every single day. So with that being said, questions and answers. I don't know if I have the answer to the question there, but I can try. If not, disclaimer. So any questions? Yeah.
We do have a question from online. What is the quantity of sick leave hours for part-time?
Part-time. Nope, there's no part-time exemption there. Nope. It's the same thing. You have to hit those same thresholds, right? So, I mean, there are certain, you know, restrictions on when they can use it, when they start, right? There's a 90-day for new folks. The general requirements, they have to work 30 days for the same employer within a year, but there's no part-time. It's not like other laws. So unfortunate, but that's actually a very common question. Any other questions? Anything HR related? Anything construction related? Well, on behalf of the North Austin Construction, Labor and Employment Departments, we thank you for your time. Ask any questions that you have. Thank you.
In going over the new 2024 cases and using a couple 23 cases, thanks for not using a Bangor list or whatever it is.
We almost did.
I would say what's hot right now, or what is perhaps an unfortunate trending law that is biting contractors in recent years that maybe if they hadn't been aware that they ought to be more cognizant of. You mentioned the Fresno one. Everyone wants to sue Fresno now. And I was interested.
Yeah, that's a loosely spot. So what are we seeing that are slipping people up?
So one thing that has not really worked its way through much are COVID impacts still on projects. So to the extent, you know, back 2020, 2021, you have owners tend to have varying degrees of sophistication, as we all know, in contracts. Some, you know, very sophisticated, some not so much. Some have force majeure clauses or act of God clauses. Some don't. And so you've got this whole landscape now where a number of claims are beginning to work their way through for delays, for impacts, for all kinds of issues, you know, the 2020, 2021, 2022 timeframe that don't necessarily fall within the box of the contract. It was new uncharted territory for everyone. So I do think there's still some struggle going on with that. You do have a lot of decisions coming out that may interpret, you know, a particular contract, a delay occurring there based on the specific terms, how a force majeure or an act of God clause is interpreted. So you have you have some of those issues, I think, that are still kind of working their way through.
Yeah, I was going to say supply chain issues. Yeah, we're definitely seeing those. People, you know, contract had been signed 4 years ago. And of course, you know, people aren't really contemplating at that point all the issues that switch gear, et cetera. So I think we're seeing that more and more, kind of go back to contract and saying, we don't have a leg to stand on here, so how are we going to make a claim? How are we going to help the contractor get, like Scott said, time extension or escalation claim? So those are ones that we're still dealing with. Luckily, the escalation claims are not as prevalent as they were a couple of years ago, but we're still seeing those. And I think lien laws, what is completion? So times to trigger a lien, and if it's not your standard notice of completion, now it's 30 days or 60 days. It's what is completion. The law changed a decade ago, and people still don't understand that there's a definition of completion that could be different. And so we get back those questions a lot from people. Like, what is completion? Well, we gotta look. Here's the statute. So I think that's another thing that people still kind of put into place and understand, because that didn't change. So, but and I think the procurement, the types of projects, so the design, progressive design build contracts are evolving. I think we're seeing a lot of that too.
Good question, Greg.
Okay, well, thank you so much.
Thank you for the vendor team for having us.
You're always welcome. For 10 10 more years.
Yes.
100 more.
Deal. We'll get more gray hairs.
We have another class coming up in March. It's about self-funding and captives and empowering your finances. I will be emailing this out as well as a link to register after our session today. And as a reminder, both the recording and a copy of the slide deck will be forwarded to you. So can we put it together again for the Thank you all for joining us. Happy Valentine's Day.
Yeah, happy. Great day. Same thing.